All right. Good evening, everyone. We'll start in a couple of minutes, about 3 minutes after. All right. Good evening, everyone. Let's go ahead and get started. Last week, we were looking at sources of international commercial law. Tonight, we're going to shift to really the first piece around international sale of goods. But first, let me just ask any questions or comments leading on from anything we've covered so far. All right. What I want to start is this idea of international commerce. When we talk about the pieces, what are we actually talking about? And one of the confusing bits is actually thinking through all of the parties and transactions involved. And that's something that certainly the news stories will help with, but also some of the discussions. So if you're thinking about it in the simplest possible way, one is really thinking about three different transactions. One transaction is a commercial sale and purchase. In other words, someone is selling something, someone is buying something. And typically, this contract around the sale and purchase will be the center. This contract will be the one that really brings all of the other pieces together. But that doesn't necessarily mean that all of the parties to the entirety of the transaction actually are involved in the purchase and sale contract at all. In many cases, they're not at all. They are actually separate ancillary agreements to that sale and purchase between the core parties. The second piece is always necessary. There will always be the necessity of payment. Typically, as we're going to see when we start looking at the UN Convention on Contracts for the International Sale of Goods tonight, payment terms are a core contractual term. In other words, if you are buying something from me, one of the most important things, in addition to what it is that you are buying from me, is the price. We don't have to have a price, but it's kind of a strange agreement if we don't have a price. And core to that price, which is going to be really our focus next week, is the way that that is actually paid. And the payment terms are something that are related to the sale and purchase, but very often a separate transaction. The contractual terms are usually in the sale and purchase agreement, but the actual mechanisms for the payment are typically something separate from the agreement. Related to the payment, and so if you think about this, there's, in any commercial, international commercial transaction, there's going to be a sale and purchase. Someone is selling something, someone is purchasing something. There is going to be a payment term in that arrangement, some sort of payment term. There may be a financing arrangement. A financing arrangement is not necessary, but it is very frequently there in a variety of different forms. One that we're going to see very commonly is a form of, if you will, purchaser credit. In other words, it's very common globally in just about every industry for big companies which purchase a range of inputs into their final outputs to pay after 30, 60, 90 days. And effectively what they're doing is they are getting a loan from the seller of those inputs. So financing is payment plus time. If the payment takes place at the same time as the sale, purchase, and delivery, that, as we've talked about, is an instantaneous transaction. There isn't necessarily any financing involved. But financing is very frequent in a wide range of forms, and we're going to be looking at that over the next couple of weeks as we also look at payment. And finally, this idea of delivery. In other words, something is being sold, that thing is being purchased. It may well be that it is simply a handoff from you to me. That's delivery. But very frequently in international commercial transactions, the delivery involves various aspects of time and distance. In other words, whatever is being purchased and sold has to make it from where it is to where it's desired to be. And note that that's not necessarily where either the purchaser or the seller are. It's very frequently the case that the purchaser of something may want it delivered somewhere else as part of a process. And so the delivery and the means of transport that goes with the purchase and sale, this is once again a separate transaction. And as we've seen, the necessary pieces are really the sale and purchase and the payment. There may or may not be shipping or transport involved. There may or may not be financing involved. But very frequently, there is shipment and transport. Very frequently, there is financing involved as well. And what this means is that one can get quite a large number of parties involved in the transaction. In other words, one can think about the sale and purchase. That may just involve the seller and the purchaser. The payment, if it's cash, that may well not involve anyone else. But a cash payment is less and less common in international transactions today, of most legal sorts at least. That means that one is typically adding in some sort of payment mechanism. There may be a bank, there may be a credit card company, there may be a variety of other parties that are involved in the payment process. And in fact, there may be quite a lot of parties involved in the context of the payment process. It could be, once again, relatively simple. In other words, if you actually have two parties that are making a direct transfer, for instance, of Bitcoin from two specifically held wallets that are not via a third party, but rather directly engaged through downloading the software and setting up your own account, that could potentially not involve another party. But it does involve a technology. It does involve blockchain technology, the Bitcoin blockchain, which is necessary for that transaction to take place. So we add in payment, we typically add a variety of parties and technologies. Similarly, depending on how the financing is structured, we may add a variety of different parties which are involved on either or both sides of the transaction. And finally, from the standpoint of shipping and transport, there are a huge number of different forms that we can think of, and in many cases, one may well be looking at multiple forms of transport which use different contracts for each piece, and a variety of different contracts for carriage, transport, etc. There may be financing related to those, payment for different elements, and of course, a range of insurance. And that begins to highlight that as we think about what we think of in some cases as a simple transaction isn't actually that simple. I'm going to pull up something that we looked at last week. So this is the key trade documents and data elements, the handout that I gave you for last week. And last week we looked at one piece, which was this list of various forms of standardized documents. And so you have the standardized forms where you have different standardized documents on one side, standards existing but without interoperability, and areas that are still at early stages of standardization. This chart essentially breaks those standardized documents, and they focus on the 36 most widely used documents into those three big categories that we've just looked at: buy, ship, and pay. So if we think about commercial processes, a purchase order, a commercial invoice, we can think about transport processes. On the right, these are typically your private law transport documents. On this side, on your right, so your left, your right, the C, these are typically regulatory documents that have to be addressed as part of cross-border transit. And finally, if we look at from the standpoint of payment, letters of credit, payment confirmation, bill of exchange, and promissory notes. And this doesn't really extend into the financial processes. These are simply major forms of payment. So, back to our framework. At the base level, a commercial transaction is going to involve at least two parties in different jurisdictions. There may be a range of other parties involved who may be in the same or yet different jurisdictions. Our core sort of risk management process involves contracts. In other words, mechanisms where we try to allocate the risks across the various parties and set out the rights and obligations between those parties in different aspects of the transaction. And once again, always start with that instantaneous transaction. That is always going to be your simplest transaction, and at the end of the day, it may not necessarily require any legal support whatsoever. In other words, if we are here in this room and we agree to buy and sell something, you take possession, there's a payment, the delivery takes place, and it's done. There, however, may be, even in that instantaneous transaction, issues around not only control, but actual ownership. And that's something that one also has to always think about. As we add in time and distance, risks increase, and we add more contractual, and in many cases, more, today, technological arrangements to try to manage the risks that are involved in order to make the transaction as efficient and cheap as possible and enhance its predictability. How can we say that this has worked? We can say that it has enabled in international commerce high degrees of complexity and specialization on a global basis. And we looked at the various ways, the sort of sources that we see where governments, parties, organizations, businesses, scholars, and others have tried to look at essentially the transactions and figure out ways where one could use legal mechanisms or technological frameworks in order to better manage those risks. And we saw, likewise last week, this core list of organizations involved most frequently. But we also saw last week a couple of others. Think about GAFTA, the Grain and Agricultural Food Trading Association. There are lots of other organizations, some private, some public, that are involved in various sorts of processes. And if we want to think about one of those, and if you want to think about in terms of formality, one of the most formal legal tools that we have is an actual international treaty. And one of the ones that has been most widely used is this, what is called the CISG, the UN Convention on Contracts for the International Sale of Goods. Adopted in 1980, became effective in 1988. As of the beginning of this year, it has been adopted across 97 different jurisdictions. And I think it's very interesting to start. We saw last time on the UNCITRAL website that very handily they provide a status chart. And if we look at the status chart, as I said, as of the beginning of this year, 97 different countries have actually ratified the Convention on International Contracts for the Sale of Goods. And if we look down in terms of major economies, Brazil, we find China at quite an early stage, really from the very beginning of the convention. If we look down, we can find France here, also an early adopter, Germany a couple of years later. We can see Japan here, Russia, 1991, Saudi Arabia, 2024, one of the more recent adopters, Singapore, 1996, Switzerland, 1991, USA, 1988, total of 97. So, Turkey, 2011. So if we look at it in terms of breadth, quite a broad spectrum, particularly of major economies, but also of smaller economies, both developed and developing. Anyone notice one that's missing here? Anyone that you want to check to see if is on the list? Yeah, UK is not here, which is quite an interesting one. The UK has decided so far not to implement the convention, but it has, in the context of UK sale of goods, one in terms of, in some ways, a competitor, but also a similar framework. But what we can say is that this framework is widely adopted, particularly if we think of it as a private international law sort of treaty, a treaty that establishes a framework for international sales of goods contracts. Now, if we look at this, purpose of the CISG is to provide a modern, uniform, and fair regime for contracts for the international sale of goods. Thus, the CISG contributes significantly to introducing certainty in commercial exchanges and decreasing transaction costs. Remember our framework, this idea of enhancing predictability, reducing transaction costs. You can see in the context of the CISG a direct focus. Contract of sale is the backbone of international trade in all countries, irrespective of their legal tradition or level of economic development. CISG is therefore considered one of the core international trade law conventions whose universal adoption is desirable. So this, if you look at it, it's across not only a wide range of different sizes of economy, but also a wide range of different developmental levels of economy, and also across a wide range of different legal systems. And so it's a framework that is really designed to cross all of these. If we look, key provisions. CISG governs contracts for the international sale of goods between private businesses. So this is an interesting one. This is an international treaty that is designed to govern transactions between private businesses, excluding sales to consumers and sales of services. So this is wholesale, this is commerce, not retail sales, and it excludes service and certain specified types of goods. It applies to contracts for sale of goods between parties whose places of business are in different contracting states. In other words, if you think about this from the standpoint of its application, one side is that if you have two parties, one party from Brazil, one party from China, these are two contracting states to the CISG. And the implications of this are that it applies automatically to those transactions. In other words, this is, by definition, the default legal system applying to contracts between two different jurisdictions. And if, of course, we look at, from the standpoint of, I guess the other one that is missing from the list, in addition to the UK, is also India. So we see India and the UK are probably our two big standouts that are not in. But if we wanted to think about, for instance, transactions in goods, world's largest goods exporter, China. Now, of course, when it joined the treaty in 1981, when it came into effect in 1988, China was certainly not the world's largest exporter of goods. It was, in fact, a tiny exporter of really just about anything. But today, when we think about China as the world's largest exporter of goods, and the fact that for a very large number of countries which have also signed the CISG, this is going to be the standard framework governing contracts between private businesses in those two countries. And that is quite interesting because it means that we have this instrument which was developed in the early 1980s that today now governs a very large amount of transactions between really China and most of the world. And that, I think, is an interesting starting point. Let's pick up slides. So, if we look at the structure, preamble, Part 1, general rules, Part 2, formulation of contract, offer, acceptance, revocation, Part 3, substantive rules, obligations of the buyer and the seller, nonconformities, delivery, notices, remedies, passing of risk, provisions common to the seller and the buyer, and Part 4, final provisions around ratification and entry into force. And so what you actually have is a convention, an international treaty, that lays out as standard contract terms for international sales transactions. If we look at applications, I just highlighted this. Article 1, this convention applies to contracts of sales of goods between parties whose places of business are in different states. So it applies automatically, as I've said, under Article 1(1)(a) when you have two countries that have ratified, that are contracting parties to the convention. So that's automatic. Second, when the rules of private international law lead to the application of the law of a contracting state. In other words, if you have, for instance, a contract for sale of goods between China and the UK is not a contracting state, but if rules of private international law would lead to the choice of Chinese law, then effectively what you would get is the CISG. So in many cases where only one party is a contracting state, in many cases the CISG will still apply in that transaction. The fact that the parties have their places of business in different states is to be disregarded whenever this fact does not appear either from the contract or from any dealings between them or from information disclosed by the parties at the time. Neither the nationalities of the parties nor the civil or commercial character of the parties or of the contract is to be taken into consideration in determining the application of the convention. So, places of business. This is really your key piece. Where are the places of business of the two parties to the transaction? And if we think about places of business, Article 10 defines place of business, regular and stable, must be real, connectious. Temporary place of business is not sufficient. Multiple places of business, the one with the closest relationship to the contract, habitual residence, where not otherwise apparent. So, if we look at this, it's actually quite a surprising sort of arrangement that you have between almost 100 countries, including most of the world's major economies from a wide variety of different contexts, the fact that they've actually agreed and signed up to a convention that sets out the standardized terms for contracts between private sellers and buyers of goods between the members. And if you think about it, this goes directly to that idea of enhancing predictability, reducing costs, increasing certainty to enable the standard contract to make transactions easier between parties. In other words, there's a framework that you don't have to spend a lot of time on trying to figure out what the core terms of a contract are. These frameworks are well known, and as we'll see at the end, from the standpoint of dispute resolution, very commonly subject to international arbitration in a variety of different jurisdictions, whereby arbitrators are very familiar with the standard terms, and this provides a high level of predictability from the standpoint of parties. So, if we look at other pieces, Article 4. Article 4, the convention governs only the formation of the contract of sale and the rights and obligations of the seller and the buyer arising from that contract. In other words, this is the contract for sale. Now, there are certain things that we are going to see will come into those standard terms, but there are a wide range of things which don't fall in. So we can see certain types of transactions like consumer sales, auctions or executions, or other sales by authority of law. But the big one is consumer sales. This is designed to be between commercial parties, not retail parties. Certain specific types of goods like stocks, shares, negotiable instruments, investment securities. So these are all basically financial instruments which are excluded from the convention. Ships and aircraft. Ships have a very specific framework for transactions and are separated out of this. Similarly, aircraft and aircraft financing are also separated, and as we'll see later, separate mechanisms which typically govern those sorts of transactions. And electricity, which of course at the time this was made wouldn't have seemed like that interesting of a transaction, but today we are seeing very rapid development in cross-border electricity markets, and we'll come back to that later in the course. Contracts for the party who orders the goods undertakes to supply a substantial part of the materials necessary for the manufacture or production. Essentially, think about this as the idea that you are providing all of the pieces to someone who then puts them together. This is the idea of piecework. Contracts for which labor is the predominant proportion, this is goods and not services. The validity of the contract, the passing of property, product liability, and questions of mistake, fraud, and unconscionability. Domestic law, though, as we're going to see, there are a variety of other instruments from an international commercial law standpoint that have been developed, which seek to address some of these aspects. So, parties can contract out. It is a default provision. Rules of interpretation. Article 7 restates the need to promote uniformity and give regard to the international character of the convention, as well as good faith in its interpretation. And this is something that is often a focus that is interesting about the convention, is that in fact it carries with it some level of good faith expectation among the parties. And so Article 7.1, regard is to be had to, quote, the observance of good faith in international law. And there's some dispute about exactly the meaning of this. There's certainly a large group which basically says that, yes, parties do have an obligation to act in good faith, and it's not possible to confine the invocation of the principle to issues of interpretation only. In other words, that it's not just good faith interpretation, it's a general principle throughout the contract. Or, on the other side, parties do not have a direct obligation to act in good faith. It is only for judges and arbitrators, a rule of interpretation which asks them to observe the principle of good faith when they interpret the CISG. And some is that it's a general principle of law and directly imposed by Article 7 directly. And there is a fair amount of disagreement on exactly the operation of this principle. But at the least, you will have, in many cases, efforts as we get to dispute resolution. Arbitrators will, in particular, try to take a commercial approach to dispute resolution. And this is really important because when we think about a commercial approach to dispute resolution, it focuses essentially on the idea that parties wanted to do business with one another. And the fact that there is this commercial idea, that this is a commercial transaction that the parties entered into because they wanted to enter into it, that means that even just interpreting in good faith means that one is looking for a commercial view on the agreement. It's not an overly legalistic analysis. It's one that focuses on trying to make the commercial agreement work whenever possible. But when it's not possible, realizing that sometimes things have changed, and then the purpose of the arbitrator, the dispute resolution system, is to come to a result that is fair to the parties. Sometimes things don't go according to plan. You haven't planned for everything. Maybe you've forgotten a key term. Something has happened that has changed the situation. And generally speaking, commercial interpretation tries to make the transaction work, or where it doesn't work, to have it end in a way that is as fair as possible to both sets of the participants. And this is often quite different to what we may see in the context of some legal systems, where there is a highly legalistic interpretation, less focused on commercial reality of transactions. So, gap filling. This is something where we're going to see throughout the course a number of areas where we have standardized trade usage, definitions of terms, systems which are frequently adopted. And in this context, there's often the use or the import of trade usage into the contractual framework. And Article 9 highlights parties are bound by any usage to which they have agreed and by any practices which they have established between themselves. Parties are considered, unless otherwise agreed, to have impliedly made applicable to their contract or its formation a usage of which the parties knew or ought to have known, and which in international trade is widely known to and regularly observed by parties to contracts of the type involved in the particular trade concerned. This will make a variety of our sort of ICC standards, particularly in relation to transport and shipping terms, potentially relevant. It also means that in the context of specific industries, remember we saw the grain industry last week, the standard terms used in an industry like grain by commercial grain companies, the assumption will be that unless there is some reason why they have indicated that those standard trade approaches will not apply, the assumption is that standard trade approaches do apply. And this is something that the CISG supports. Contract formation. Interesting, a convention that actually lays out contract formation. Article 23, an international contract of sale comes into existence when the acceptance of an offer becomes effective in accordance with the provisions of the convention. So acceptance, an offer is under Article 14, intention to be bound, definite, and essentially the offeree accepts the offer made by the offeror. One thing that we do see is this idea that sending of price lists, catalogs, placing of advertisements and the like is in principle not an offer. These are simply informational materials, but a reach out to say that we would like to contract on this basis, and an acceptance will then result in the creation of a contract. Contract formation includes also revocation provisions, rejection, counteroffer, and contract formation. Acceptance, a contract is concluded at the moment when the acceptance of the offer becomes effective in accordance with the provisions of the convention. Any statement or conduct indicating assent, silence, or inactivity doesn't mount to acceptance in general, variation from the initial offer. Variations amount to rejections unless they don't materially alter the offer and the offeror does not object. What you see in the convention is essentially standard terms. And the end result is something that is designed to make transactions easier. Obligations of the seller include delivery of goods, conformity of goods, and goods must be free from third-party rights. Under the convention, delivery is the physical handover of goods to the buyer. So one needs to set in the contractual terms nature and place of delivery, time, carriage, depending upon how the delivery is to occur, documents. And this, as we're going to see in the context of delivery, the documents are very important and relate directly to different contracting systems which apply to different forms of carriage. Carriage of goods by sea is very different from air, for instance, as we're going to see. And aspects around premature delivery, which is usually okay, and excessive quantity. Conformity of the goods. Goods must be of the quality, quantity, and description required by the contract and are packaged in a manner required by the contract. In other words, there's the expectation that the contract will set quantity, quality, and description, as well as delivery times and mechanisms. Goods conform if they are fit for purpose for which goods of the same description would ordinarily be used, unless there is an agreement otherwise. Typically, key elements will be set out in the contract, and we think about, final bit, goods must be free from rights and claims of third parties unless the buyer agreed to take the goods subject to that right or claim. This becomes highly important when we start looking at financing mechanisms, which in the trade context usually are attached in some way to the good that is being delivered. And this means that very frequently the financing is going to be specified in the contract because the delivery subject to certain rights and claims of third parties who may well be financiers are actually core to the transaction. We also see in many cases that the seller is often the financier. Sometimes the buyer is the financier. Sometimes there are a variety of third parties. And depending upon the way it's structured, each of these may have certain rights that they retain in the transaction, and that these are important to likewise have in place. Obligations of the parties, of the buyer. Pay the price. Obviously, a core term for the contract is the price, and the way that that price is paid is a central term. And, of course, to agree to take delivery of the goods. This is something that last year we actually saw a lot of very interesting examples because Trump had just come in and was putting tariffs on all sorts of things all across the world. And in many cases, you would have a party where a transaction had been agreed on the basis of the environment and pricing pre-tariff. Now, if, for instance, in order to take delivery of the goods, the buyer of the goods actually has to pay, for instance, U.S. customs charges in the context of tariffs on that product, we actually had a large number of situations where Buyers, in particular, were simply walking away from transactions, basically saying that if you add on 100% tariff that we have to pay as part of the import process, this transaction no longer makes sense. And so you would have shippers where a ship had left, the goods had been put onto a ship, tariffs come in while the ship is on the ocean. Often examples where, for instance, a date may happen, and you would have had last year shippers racing to get their goods to port before that tariff would come in. Because if they didn't make it, there was a very good chance the buyer would simply walk away from the transaction. And if you are a ship full of whatever it may be, Chinese toys, what do you do with them? You have to find a way, and that's an expense, to get rid of the things. And in fact, you may have to pay, as part of the unloading process, the tariff yourself to deliver into the jurisdiction, which is certainly something that you didn't have in mind in the context of the transaction. So, in the past couple of years, a number of things that we often really didn't think about as being actual problems have emerged with some frequency. And this has led to not only some very interesting examples like the ones that I've just highlighted, but also quite a lot of disputes where parties have had to go to arbitrators to basically say, you know, what is commercially, this is something that nobody would have anticipated. What is a fair result from the standpoint of the parties? And often, you get very different results if you have a continuing relationship. In other words, if you have a commercial relationship, we talked about in the first class the example of Apple and Foxconn. This is really a symbiotic relationship. And so, if something changes in the context of their business environment, in many cases, they will negotiate to come up with a new result themselves. But if one does end up in the context of a dispute, the fact that these are two long-term counterparties and with the commercial expectation of a continuing relationship, you'll have a different result than where you have a seller and a buyer, where basically the buyer and the seller, this is a one-off transaction. They don't know one another. They've never done business together before. Something has happened, and both of them are trying to avoid the extra costs. And so the ways that a commercial arbitrator will deal with commercial transactions are often quite different than you might see in other contexts. Time of payment, a very specific term, and often this will go together. We're going to see an interesting example from China next week, which highlights the way in which payment systems can extract time from suppliers. Place of payment, and in many cases, no obligation to pay until the buyer has had the opportunity to examine goods, unless there is some sort of embedded third-party inspection mechanism. Buyer's obligations, payment of the price. Typically, the obligation to pay covers 4 elements: determination of the price, place of payment, time of payment, method of payment. And this, when we start to turn to payment next week, is how we're going to focus on this. Essentially, price, place, time, and method. Remedies are generally going to be damages, but in some cases, the opportunity, particularly for the seller, to either deliver substitute goods or to repair goods, or in some cases to actually replace. And so, once again, the approach of the CISG is commercial. This is not an agreement that is designed to be focused on law above commerce. It's commerce in the first instance, with the terms designed to make commerce simpler and more predictable. Calculation of damages can be common to both. It's the sum equal to the loss, including loss of profit, suffered by the other party as a consequence of the breach. It's commercial, so there's a duty to mitigate any loss suffered as a consequence of the breach, and the possibility to recover loss due to price difference between the original and any substitute transaction. Remedies, specific performance is generally, along with damages, preferred structure. In some cases, however, going back to this idea that sometimes circumstances change, there is the possibility of fundamental breach and contract avoidance. In other words, if you have what is a fundamental breach, and the fundamental breach is essentially there has to be a detriment, the detriment must substantially deprive the non-breaching party, and the result must be foreseeable. If the breach is fundamental, the non-breaching party is entitled to avoid the contract. In other words, this is a circumstance which fundamentally means that circumstances have changed to such an extent that the contract no longer makes sense and the parties wouldn't have entered into it in the first place. Generally speaking, though, the approach is going to be to make the contract work. That's the commercial approach. Avoidance, fundamental breach will only be found in essentially extensive problems that were unexpected and unanticipated. Seller's remedies, damage specific performance, obligations. Okay. Let's take a break here, come back, look at a couple of these pieces again, and then move into two other pieces. One, some of our examples, but also one thing, if we note the date of the CISG, agreed in 1981. That means that most of the negotiations took place in the 1970s. Now, if we think about technology between the 1970s to today, it's been a big change. And one thing that is not really taken into account in the context of the CISG are technological changes. And I want to come to that next, because probably one wants to think about where have we had the most successful examples. One is this. Another, as we saw when we were looking at sources last week, is very much around the dispute resolution systems. But a final area where we've had a lot of success has been in the context of dealing with new technologies in international commerce, in particular in the context of sales of goods. So we'll pick up also with this idea of the impact of technology. So let's take a 10-minute break, come back at 7:15.
I got enrolled last week,
Okay.
but for some reason, at the QM Plus app, I cannot put my attendance score.
No problem. Let me just, it's actually,
The same thing.
okay. Yeah. Let me see if I can find your name.
Anna,
That doesn't look like you're, yeah, it doesn't look like you're in yet, so let me just double check. Yeah. Try the surname just in
Uh,
case.
K A B.
No.
Ah, okay.
So-
So we're not
Yeah,
looking.
we're still
Can you-
same GHA.
Because they sent us an email
Yeah,
that we
I
are
would like-
enrolled.
Okay, so they just haven't got you.
Okay.
It's not unusual, so.
Okay.
Yeah. Hey.
Yeah, is it possible to ask a couple of questions about the scope of the convention regarding Article 1 more after the lecture?
Yeah.
Okay, yeah. First question. Let's consider the situation when both counterparties are not signatories to the convention, but, for example, the law of Italy is applicable to the dispute, and Italy is
A convention, in which
yes.
case, yeah, the end result is effectively yes. You
So
end
it
up
will be
with-
applied in this
Yeah,
case.
exactly.
Okay, and the second question is connected to Article 95 about reservations
yeah.
of applications
Yeah.
of 1B. So for me, it's quite clear that if the dispute is held in the courts of the UK, no, bad example, in the courts of the US, for example, so and the US made this reservation, even if the law of Italy, even if it is applicable, we won't apply CSG. Quite clear. But what if we have the opposite situation? The dispute is held in Italy, so and under kind of private international law rules, we are supposed to apply the law of the USA. But in the USA, they made this reservation. Would we apply the law of the USA with CSG or without CSG? Because
It could vary a bit. I would say probably the tendency would be just to apply with CISG in most
With-
cases because it's simpler.
so we would apply CSG.
Generally. And it depends a bit on the arbitrator and the
Okay.
parties, but generally that's what the arbitrator will
Okay.
tend to do. Because they know CISG, and so they'll go with
Okay.
that. And
So
they'll try
article-
then to find an excuse to say why they've
It's not
gone with
applicable.
it. Yeah.
Okay, so Article 95 and is applicable more when the dispute is held in a country which made the reservation.
Exactly.
Okay, got it. Thank you so much.
But it's almost always the case that the arbitrators, because they know CISG,
Uh-huh.
that they will try to apply.
And then okay. Thank you.
Yeah. Hey.
So hi. So I was enrolled at a later stage
Yeah.
and I was not updated about the class. So apparently you've missed two classes now. Is there, I will go through the slides of course,
Yeah.
but if there's any free time you can get up to catch up or something like that.
I mean, we'll do a bit of it in the tutorials this week. So,
And,
yeah. Yeah. Hey.
I could just get the attendance.
Yeah. So. There you go. Yeah.
Excuse me.
Yeah.
I couldn't check in myself because
Yeah.
I have a problem in my application. You see, we take a break to.
Yeah, no problem. Let me see. Yeah. What's your surname?
It's Mohammed.
With an E or an A?
It's ED.
This one?
Mohammed. Yeah.
Okay.
And last week it's my first class, but I didn't have idea about how I can check in. I sent email to you.
Yeah. Then I'll get it in.
Thank you so much. I appreciate it.
You're welcome. Hey. So basically what it says is that generally if there is some sort of industry usage available, unless the participants have agreed to exclude it, they will generally include it.
An example to make a point.
Yeah, so think about our grain example last week. You're a grain seller and I'm a buyer. We saw last week that the vast majority of contracts are under those terms. So an arbitrator would generally assume that those standard terms and procedures will apply because we are in the grain business.
Okay, so basically that means if a country is a party to the convention, it means the terms of the convention would automatically apply.
No, so in other words, it's basically so the terms will automatically apply, but what the Article 8 is actually saying is that assume that we're in the grain business. You are a grain seller, I'm a grain buyer. That's what we do. Generally, the grain business, there are standard ways that things are done. And so the convention assumes that unless we say those don't apply, that they will assume in a dispute that they do.
So in terms of the field that basically the buyer and seller operate in, so the general standards of a specific framework that we work in, they will assume that it applies just because they work in that.
Exactly.
Okay.
Yeah, because they're commercial parties, and the assumption is that there's some industries where you don't necessarily have standard commercial practice, but there are lots of industries where everybody does things in a certain way, and so the CISG assumes that where you have two commercial parties in an industry,
It takes consideration the framework of that specific industry.
exactly, unless they exclude it.
Unless they exclude
You can exclude it,
expressly in the
yeah,
contract.
you can
Yes.
exclude it, no problem, but
But if
otherwise,
it's not excluded, then they will
you
assume
just
that it
assume
applies.
that because you're a grain seller and I'm a grain buyer, that we
Yeah.
know how grain business is done.
Yes. Okay.
Yeah.
That's quite clear. Thank you very much.
Yeah.
I have another question here, and the notable features. It says here like the seller-friendly versus buyer-friendly jurisdiction. So I kind of get the idea, but I don't know how it is in practice actually.
Yeah. So often you might think of like the UK is often seen as a more seller-friendly jurisdiction. It's often because many of the arrangements dealt when the UK was selling things to the world, and so the legal system often has default
benefits,
protections that protects them more, whereas other jurisdictions, particularly developing countries, may be more buyer-friendly in terms of.
So this maybe like China is assumed as a seller-friendly jurisdiction, maybe?
You would actually, historically, when China, you would have assumed they would have been more buyer-friendly because they've only emerged as a big seller in the past 2 decades.
Okay.
So historically, they would have been much more sort of buyer-friendly. But the CISG is designed to try to really make it balanced.
So is that really, is it in terms of, I would say, like general protection, benefits, or taxes? Is it just like a package of everything?
It's more or less just the package of everything. This idea that it's meant to be, these are commercial parties, it's a commercial agreement. You want to interpret things to make that work. That's the objective. It's not about imposing someone's terms on someone else. It's about
It's like achieving balance between
exactly,
the two. Yeah.
exactly,
Okay.
and that's really the difference. And often we'll see this in like, hey, they impose terms on, and this is designed not to do that.
So one of the objectives, we would say, of the CISG is kind of to achieve that balance between these two types of jurisdictions.
Exactly. The assumption is that these are commercial parties and they should be treated
Yeah,
as
equally.
exactly,
Yeah.
exactly.
Thank
Yeah.
you.
Yeah. No. Good question. Hey.
No,
Yeah.
it was going on.
Ah, sorry.
It's until 7:15, right?
7:15. Ah, I'll grab one later. Thank you.
Okay, I'll give it to you later. Have
Yeah.
some, like extra left over.
Sounds great. All right, let's go ahead and get started. What I really want to pick up is back to this piece. We just saw in the context of the CISG that it essentially lays out the key terms for commercial sale and purchase. It lays out, if you will, the default legal treatment of common aspects of international sale and purchase. But we also saw that it requires to be embedded aspects of the payment, in other words, place, time, amount, etc. And we also saw that it requires and actually sets standard terms around delivery. In other words, the goods, there needs to be set how the goods are going to be delivered, when they are going to be delivered, where they are going to be delivered, and essentially in terms of the acceptance and quality of those goods. But what the contract doesn't lay out is necessarily the mechanism whereby the payments take place, the shipping and transport takes place, or if there is financing, the mechanisms by where that takes place. And if we look at this, we can see in this framework this idea this is the ICC Digital Trade Initiative document from 2 weeks ago, that you have standard documents for purchase orders and commercial invoice. Now, let's actually pick up one in a bit more detail. So this is the ICC Digital Standards Initiative. But let's actually go back to, this is the ICC website. The ICC website, if we look under Business Solutions, we'll see in particular Incoterms later, but I want to pull up ICC model contracts and clauses. We find here ICC model contract for international sale of manufactured goods. It's not a free document. It is something that has to be purchased from, but can be simply downloaded from the ICC. But if we look at the description, the model contract is specifically adapted for transactions governed by the UN Convention for the International Sale of Goods, which applies to an increasingly large volume of international sales. This is thus a standard document which takes that CISG framework, puts it into a contract with blanks, which can then be filled by the party. Each ICC model contract includes a fully editable version in Microsoft Word, permitting you to easily adapt the contract to your specific case. And of course, this is something that if one thinks about particularly large commercial businesses, one would expect in the context of a large commercial business that they will generally have their own standard form contracts. And those standard form contracts will often start from something like this, which is then tailored for the specific needs of that commercial party. Other commercial parties may have their own, and frequently there may be a process where there is some level of negotiation between the legal teams of large commercial counterparties in the context of larger transactions. And increasingly in the context of use of a variety of AI and otherwise automated systems to simplify processes. In other words, if you have two large commercial parties, each with their own standard agreements, those agreements in all likelihood are going to agree on almost everything. And the AI system can be used to identify the differences which can then be negotiated. In many cases, though, where one is dealing with, for instance, a large commercial counterparty, there will be very little negotiation on the part of smaller commercial counterparties because the negotiating power of a large business versus a small business is often very disparate, and the large business will often have its terms adopted almost automatically by smaller counterparties, more or less in a process of imposition. Large party imposes terms on smaller parties, but at least to the extent that one has standardized terms in line with the CISG, one knows that there is a certain level of commercial balance intended in those designs. So if we look at this, an international business transaction requires a precise and detailed underlying contract. However, it can be expensive and time-consuming to draft such a contract. With the ICC Model Contract International Sale, the ICC provides a solution in presenting a set of clear and concise standard contractual conditions for the most basic international agreement. Although this model is denominated a sale contract, it is equally appropriate for use by buyers as it balances the interests of exporters, sellers, and importers, buyers. It may be used also for a so-called purchase agreement. Model contract is divided into two parts: specific conditions and general conditions. Specific conditions allow the parties to use the model directly by filling in the blanks, while the general conditions provide a platform of standard legal terms serving as a reference tool for contract drafting or negotiation. These general conditions may be used together with the specific conditions or independently. And of course, the contract provides a provision to choose ICC arbitration as a dispute resolution system embedded in the contractual framework. So what you can kind of see here is how one starts out with a commercial transaction, buying and selling. That would typically have a contractual framework, but because of essentially the benefits to buyers and sellers across the world in having a commercially acceptable, balanced legal framework, you've had the development of the CISG, you've had its ratification by a large number of countries, and we also have, in this case, an example of standardized documentation from one of our major, if you will, private standard-setting organizations, the ICC, which is widely used in the context of the industry, particularly as it embeds that CISG framework in a way which is commercially useful for counterparties, but also provides some level of trust and assurance to anyone, anywhere that is using it. So, I think this provides, if you will, kind of a nice example of how these processes work. And as I said, we think about the ICC, in addition to business solutions, this idea of the Incoterms, standardized contracts. We're also going to see provisions around letters of credit. They also have, for some reason this is not working very well today, dispute resolution services, which come with not only a set of rules, but also panels of arbitrators and even premises, which can be used by parties to contracts. So a commercial organization embedding the international legal framework to address these issues around predictability and transaction costs to support international commerce. I'll just pick up. We can see in terms of contracts, we'll come across a couple of others. So in addition to the standard sales of goods contract, ICC agency and distributorship contracts are also available and widely used. We also see standard packages for startups. In other words, if you are a small business, the costs of setting up initial contracts can be quite significant. And so they actually provide essentially a set of model contracts for startups. And if we look at this, package includes a model term sheet, model shareholders agreement, model directors services and management agreement, model employment agreement, model confidentiality agreement, and a checklist on intellectual property rights. So basically, it's a suite of documents from the standpoint of setting up a small business. Now, that one I've done. So, back to this idea of the different pieces of our transaction, the different contracts, and the different parties. This is from this week's document, which is a roadmap for interoperability and trust. And this is perhaps a slightly overcomplicated visual representation of elements of a supply chain and relating that to core documents. So in other words, if you look at this piece, purple commercial processes, green transport processes, blue border and regulatory processes, and sort of red financing processes. So we were just looking at order placement. So this is your purchase order, commercial invoice, contract of sale of goods. This is your base part of manufacturing. Production, manufacturing, and compliance, this often has to do with regulatory processes. But of course, from the standpoint of purchases of goods, it's often a very important element, as we saw in the CISG framework, to specify the quality, type, details of goods that you are purchasing for delivery. And very frequently, this may come with things like certification by the ISO or other organizations, but it may also come with the necessity to address a variety of regulatory requirements. So we have certificate of origin. Certificates of origin, this is something that obviously in a world of increasingly complicated tariffs and also other forms of trade agreement, the certificate of origin can actually have a big impact on the commercial terms of the transaction. And in many ways, 3 years ago, certainly 10 years ago, we would have generally thought that tariff terms for most transactions were largely not that significant. But today we are in a world where tariffs, particularly involving the United States and transactions involving the US, have in many cases become very substantial, but also unpredictable. So to the extent that one is dealing today with the US as a counterparty, either from the standpoint of purchase or sale, these aspects around certificate of origin and the choice of origin from the standpoint of trying to minimize those tariff costs is often an important choice. It's of course going to be less relevant when the US is not a counterparty, but at the same time, we are seeing increasing numbers of bilateral and regional frameworks. We saw India and the EU just last week. We've seen the EU and Mercosur. We've seen a number of others. These certificates of origin, from the standpoint of how one structures a commercial transaction, becomes very important. Where you choose the goods are coming from can have a big impact from the standpoint of the costs of that transaction. And in reality, businesses are spending an increasing amount of time and effort thinking about origins for different pieces of transactions in order to minimize these sorts of costs. Export-import license, which could be for agricultural processes, or increasingly, we're seeing as a result of particularly national security concerns, but a range of others, we are seeing increasing numbers of restrictions from a variety of different jurisdictions in the context of specific sorts of goods, particularly technological goods. And as a result, this idea of the import or export license is something that one has to be quite aware of because the return of import and export licensing requirements has accelerated pretty dramatically. Cytosanctuary certificate, international veterinary certificate, CITES permit, codex, and in this case, one area where we're also seeing an increasing growth is around various forms, in addition to CITES and codex, around different forms of carbon and other sorts of sustainability requirements. This is particularly important in the context of transactions with the EU, but we are also seeing a range of other jurisdictions putting these in place. And so, from the standpoint of these various regulatory requirements, this is an important aspect of both commercial evaluation of the transaction, because each of these elements may add costs or complexities, but also from the standpoint of the due diligence process, putting together the package of documents that needs to go with something that is moving from jurisdiction to jurisdiction. Outbound transport, things like, let's see if I get, importantly, we can see, and we'll look at this obviously later, but things like choices between air transport and sea transport. And this is something that I'll pull up a little bit later, I think, in terms of an example. But if we look at air transport costs have gone down to such an extent that they become, it has become much more widely used for an ever wider range of transactions. And the mechanisms that we use in air transport versus sea transport versus road and rail transport are quite different. So, airway bills, air cargo manifests, rail consignment notes, road consignment notes, bills of lading, sea cargo manifests, and of course, the different sorts of insurance documents that may go with a process. And this is interesting because we wouldn't have until quite recently really thought about it may be a direct choice in terms of cost between sea and air. Now, obviously, there are some things, large amounts of grain, vehicles, that almost certainly you're going to send by sea. But you have a large range of other things, smaller electronic goods, the sorts of laptops that are all over this room, that they could easily be sent by sea or air. And the key is really the price differential and the distribution mechanism. In other words, if you think about something like Shen or Temo and their distribution mechanism, which basically involves direct air shipment to the customer at the destination, that's quite different from how we typically would think about a distribution model. One would typically think about something like Shen for clothing. You would think about a shipment of clothing being ordered from a manufacturing jurisdiction, loaded into a ship, which arrives at a distributor, something which could be something like a department store, where those clothes are then sold directly to retail. But of course, if you think about Shen, Shen has gotten rid of that distribution mechanism and going straight from, in many cases, the manufacturer directly to the purchaser, engaged via their platform with air transport on a piece-by-piece basis. So essentially what this says is that we're seeing, because of technological changes and cost reductions, a high level of interchangeability, particularly between transport options, in a way that we haven't seen before. And pick up one fun related news story. Unfortunate. Okay. The story I want, I'm not finding, unfortunately. Let me just see if it's on the Scission website real quick. close enough. Now, this is interesting. Those of you from China will know that in the context of China, we've seen a move, many domestic companies towards instant delivery. In other words, those of you who have dealt with the firms like Shen or Temu will know that sort of almost instant delivery. In other words, you order, the shipment will go direct from the manufacturer, often into air shipment, and deliver. What we're now seeing is an increasing focus in many different markets on faster delivery. Now, if you think about it, there are a variety of ways that this can be done. One, if we think about the Shen model, where you are essentially going straight from manufacturer to customer via an air delivery. Think about Amazon. Amazon's model is essentially it builds large warehouses spread in places across its major commercial jurisdictions. It then uses big data analytics, in particular AI, to try to figure out what it needs to put in those warehouses so that knowing that people are likely to order certain things at certain times, you probably wouldn't, if you're Amazon, put a lot of portable air conditioners in your warehouses in the UK right now. But based on last summer's temperatures, which were often in the 30s and pretty miserable because there's no air conditioning in this country, you would want your warehouses loaded with portable air conditioners in May. Because as soon as those temperatures hit, you want to be able to get delivery. So that's one thing. Supply chain management, this is the idea of big data analytics using AI for supply chain delivery. Then the idea of those delivery centers is that you will have the goods that people are likely to want to buy close to those people so that they can then get them as quickly as possible. We're now seeing moves in a number of jurisdictions towards what is effectively instantaneous delivery. The idea that you can order something and expect it to arrive in a very short period of time. And that's what this article is about. It's essentially saying that if you are a foreign company seeking to operate in the Chinese market, the expectation is that you will be able to, similar to domestic producers, deliver on an increasingly instantaneous basis. More foreign companies have rolled out instant delivery services exclusively for China or upgraded to more comprehensive offerings in the country. This comes as they vie to stand out in the highly digitalized market and cater to consumers' strong demands for instant services. Multinationals offering instant delivery now include Swedish furniture retailer IKEA, German tire manufacturer Continental, US warehouse-style retailer Sam's Club, and German discount supermarket chain Aldi Nord. What's interesting is obviously these are commercial firms, but firms like Continental and Sam's Club in many cases are actually dealing with commercial counterparties. They are delivering goods to tire sellers or, for instance, repair shops who will only order stock when they actually need it, but want it delivered instantaneously. China leads the world in internet penetration and boasts a well-developed digital infrastructure. And China's highly competitive market, providing instant retail services, can help foreign brands to drive sales growth more effectively. And this is one of those areas where transport and commerce are moving very rapidly. Methodologies are changing very rapidly as a result of technological change. And not surprisingly, we're seeing the need to bring this into commercial practices, but we're also seeing a range of international efforts to try to address those same issues around time, distance, predictability, etc., to address the changes in transaction structures. So I'm just going to highlight. So if we're looking at technology and digitalization, the first is an aside. Those of you who are reading the Good textbook, the Roy Good textbook, one thing that you'll notice pretty quickly is one area where it is really dated is the authors really don't deal with technology and digitalization at all. But that's something that in the context of what we're looking at, we're trying to add this into each of our discussions. So building upon what is there. If you look at the Twig Fleischer book, they've put in one specific chapter on technology and digitalization. And that chapter tries to cover everything. I personally don't think that either of these approaches works anymore. I think as we're doing in this class, one really has to look at the reality of transactions and technologies and look at the efforts that we're seeing in those contexts and how they relate to previous efforts. So, if I wanted to highlight from the standpoint of key pieces that we're going to see, but in particular those that relate to what we're talking about today around sales of goods, these are some of the highlights. The first, the UNCITRAL Model Law on Electronic Commerce. Note that this is different. It's not a convention. CISG is a convention. It's a treaty. That means when it's signed, it is binding from the standpoint of its state signatories. Model laws have to be implemented into domestic legal systems. So they are what we think of as soft law arrangements, but when a model law is implemented into domestic law, it's hard law. It moves from being soft law to hard law in that jurisdiction. And the model law on electronic commerce has probably been, after the CISG, one of our other most significant successful international arrangements. So far, implemented by 88 states and 171 jurisdictions. We'll come back to that in a minute. UNCITRAL Model Law on Electronic Signatures. This is an interesting one. And it's interesting because think about electronic signatures. Now, one form of electronic signature is essentially where you print something out and you sign it and then you scan it. That's a digitized signature. In other cases, one may be thinking about actually adding some form of electronic signature to a document and questions around the validity of that. But in many cases, we're actually, and this is something that we're going to pick up a number of times on, this one at the bottom, what is called the Global Legal Entity Identifier Foundation, or GLIFE. If one thinks about that signature, what's the purpose of a signature?
The agreement on the terms
Exactly.
that these terms actually apply to the selling party, therefore they're binding to the selling.
And it's proof that the signing party signed it. In other words, something that you probably don't see too much anymore, but it used to be very common. It used to be the case that frequently if you would sign something, the bank would actually call you up and say, this signature doesn't match your signature on file, because they were concerned about fraud. And so this idea is it's binding, but it's also a way to say that the party actually signed. The assumption is that each signature is in some way unique. Whether or not that's true is a different story. But once we start using file signatures, in other words, I make a signature, I take a picture with my phone, and I append that to an agreement. Well, that's now completely useless from the standpoint of proof that I actually signed the agreement. Because I've digitized my signature, anyone can take it and append it, and there is no link at all to prove that it's actually been me that's agreed to the agreement. And as a result, when we think about digital signatures, one of the key issues that we actually run into as soon as we move from print, sign, scan, send, once we try to do an actual electronic signature, is the need to prove identity. East Asia, history, we would use something for companies, a chop. That chop was something that you would keep very careful track of, because if someone took it, they could then use that to authorize things on your behalf. So there are a variety of mechanisms that we can use to prove that someone has agreed to an agreement. And increasingly what we're looking at are systems of digital identity. In other words, for most of us, think about it for a second. For most of us, most of the time, what is the way that you are identified for contracting purposes? Could be signature. What's that? PIN code, it could be. How much is face scan? Face scan, that's ID. Exactly. And this is the sort of thing that we're seeing more of. And what sorts of systems can we put in place that basically protect that certification? And this is one area where, yes, we can look at agreeing that an electronic signature is valid. But what we found in many cases is you actually need something more than that. And think about DocuSign. Almost everybody has used DocuSign. The key to DocuSign is not the sort of Acrobat-like software or the fact that it's a soft copy. The fact is that there is a digital ID framework that identifies the person either by a pen or by a face scan, which then asserts that the digital signature that is being appended in that document is valid. In other words, for me, if I'm doing DocuSign, my signature doesn't look at all like a real signature. You just do that because you don't care. It's irrelevant what the signature is because it's the ID that comes from a different system of proof that matters. DocuSign is interesting because it's basically a platform. It's a platform that allows electronic signature of contracts. And to the extent that DocuSign is recognized via something like the UNCITRAL Model Law on Electronic Commerce across multiple jurisdictions, it becomes a platform that enables commerce. DocuSign tends to run into one big problem. Most jurisdictions have actually, particularly during COVID, everybody made changes to their electronic signature laws to make it easier to contract because we couldn't come in and make physical signatures in the context of COVID. And it's also the case that quite a lot of people didn't have access to printers wherever they were locked up and couldn't necessarily print, sign, and scan. So there was often a practical necessity to quickly put in place systems which would recognize electronic signatures on a variety of forms of different agreements. One of the biggest problems we now run into is actually data rules. In other words, rules about cross-border sharing of data, and also data localization requirements, which make it difficult in many jurisdictions for that platform to adapt or to operate effectively. But DocuSign is an interesting example of a technological platform that provides a mechanism to make it easier to sign contracts in a dematerialized fashion that proves identity sufficiently for those contracts to work for transactions. And, of course, Apple and various other phone providers and their facial scan-based, particularly payment systems, are another way which we're finding used increasingly frequently. Convention, this is a convention, but of course, most conventions that we're going to see in this course aren't that widely adopted. One that is getting a lot of attention is a new model law, what is called the Lec3 model law on electronic transferable records. This is something that we're going to run into because if we think about, let me just pull up. If we think about this diagram, and of course, if we look at both of these ICC Digital Trade Initiative documents that I've given you, both of them are about trying to digitize international trade. Both of them highlight that significant amounts of international trade documentation are still not digital, particularly around things like bills of lading. And it's relatively straightforward to say that a digital representation is equivalent to the paper document. But in some cases, the paper document has some legal function that the digital equivalent doesn't manage. Think about the signature example I just gave you. Paper-based signature. The signature is legally significant. It's legally significant because it shows that you've agreed, but it's also proof of identity. It's meant to address the fraud question. But when you digitize that signature, it's no longer effective for that legal purpose. Because of course it can be copied infinite times, and as a result, it's completely useless from the standpoint of specifying identity. So we have to come up with other systems, systems which come up or which achieve that identity function that is embedded in a signature. So DocuSign is one, facial recognition scans is another. What we run into similarly is some documents, a bill of lading, for instance. A bill of lading, as you'll look at in more detail in the second half of the semester, a bill of lading is a legally significant document. Whoever has the thing has ownership of what it lists. That means that the paper is significant. If you digitize it, we can all have a copy of the bill of lading. And then who owns it? Nobody owns it because we're all fighting over who owns it. A physical bill of lading, where it's a physical bill that passes physically from me to you, that's legally significant. And if we just digitize it, we actually undercut its legal function. And so this is something that as we think about technology, one, how technology transforms transactions, but also the fact that sometimes the pieces of paper or other physical things that we use, there's actually a reason for them. They may be legally significant in and of themselves. And so if one simply makes it digital, it may no longer achieve its objective. And so then one has to think about how can you actually go about building a system which will achieve those objectives. What we've often done in the bill of lading context is it will work if it's a digital bill of lading, but it's a closed system. In other words, that digital representation can only go within a closed circle of participants. That means you can track who has it. But the beauty of a paper-based bill of lading is that it can go to anybody. And that makes it harder to achieve in a digital environment. Variety of efforts with blockchain to say that the blockchain representation could be unique, but still some issues around how effective that may be. So, that has then taken us to some efforts around identity management, both from the standpoint of the legal side, but also from the standpoint of actually creating the identity. In other words, biometrics. Biometrics works for people, but it doesn't work for companies. In other words, a company doesn't have biometrics. So what sort of unique identifier could you have for a business? And that we think about. Glyph. Glyph is an organization which essentially is not dissimilar from the ICC. It's been created by a range of governments, but it is not an international organization. It's more like an industry association. And essentially what it does is it is responsible for the processes around what we call legal entity identifiers, LEIs. LEIs are 12-digit numbers which are uniquely assigned to individual legal entities and which can then be used for identification of those legal entities. It's used in some cases, its use is picking up, but it's still at a pretty low level. We'll see it more a little bit later. There's a big area where this is going to likely emerge as a huge challenge in the very near future. Think about agentic AI, AI agents. Now, to the extent that an agent has been assigned by me to go do something, that takes us into questions around agency. What sort of authority does that agent have? And how do you identify that the agent who says it's my agent actually is my agent? Or how do you tell that agent A is different from agent B, because agent B may be claiming to represent me, but in fact, agent A represents me. And so one of our biggest challenges as we move into agentic systems is going to be not only around the powers, legal powers of those agents, but also their identification. How do you actually identify an agent? And in some ways, an agent may be the same as a company. Sometimes an agent may be the same as a human. But key to this is going to be the responsibilities, the powers of those agents, and the identification of those agents. So this idea around identity is moving beyond just individuals, where it's enough of a challenge, to companies where we've made some progress, but honestly not that much, to agentic AI, where the rate of change is going to be really quite dramatic, and the difficulties of addressing it are likely to be huge. So, take a look at each of these in turn. So, if we look at model law on electronic commerce, first is 1996. So technological change since 1996 has been pretty substantial, and that's kind of drawing us into some of these other efforts. Now, if we look in terms of implementers, remember this is not a convention, this is a model law which has to be implemented into domestic legislation. That then means that effectively legislation in different jurisdictions is harmonized but not necessarily identical. And it does not mean that you have a common framework across jurisdictions. But it does mean that to the extent the principles and terms of the model law have been implemented into two different jurisdictions, their approach is likely to be similar. So we've got China, 2004, also Hong Kong and Macau. We get France, but this time not Germany. We do get India in this case. Interestingly, Iran. We will see Iran as a party to a number of agreements. We will, however, almost never see North Korea as a party to any of these sorts of international conventions, et cetera. So a different approach in that context. If we look down, Singapore, South Africa, United Kingdom this time, US and most of the US states. So you get, in this context, most of your big economies have implemented this, and quite a range of smaller, both developed as well as developing economies. And so, if one wants to think in terms of relative success of these sorts of international commercial processes, this one does quite well. Now, what you can see is it doesn't necessarily matter what the instrument is. A convention could be really successful. A model law could be really successful. We'll see lots of conventions that nobody has signed. And we'll see lots of model laws that nobody has implemented. So it's not necessarily the instrument that determines success. Treaty-based approaches, at least until recent years, were workable. There was a view that model law approaches might be more effective, but not necessarily. In some ways, the effectiveness tends to depend on how useful something is. It's hard to judge that, though. But usefulness in some ways is reflected by the numbers of countries that actually implement something. If you see countries implementing something, that indicates that they found it useful. So CISG, clearly this is something that lots of countries have found very useful. Similarly, if we look at this model law on electronic commerce, this is something that has proven useful. And if we look at international commercial efforts, sometimes you're trying to solve a specific problem. Recognition of arbitration from the standpoint of dispute resolution systems. Other times, we see efforts where essentially you're trying to get ahead. In other words, some problem is emerging as a result of commercial or technological change, and you're trying to build a process to help it work better. And there's a good argument that the model law on electronic commerce is one of these, that they started early enough, 1990s, to get ahead of processes before many states had addressed them. And that meant that the process of agreeing cross-jurisdictional, cross-developmental levels of approach in the context of a model law has actually been pretty effective. So, mouse is really bad here. Whatever reason, it's not working. So, structure, objective, scope, structure, and essentially a framework to be supplemented by technical regulations, The idea is a term that you will very frequently hear, which is technological neutrality. Technological neutrality is one of these principles that regulators love. I hear it constantly in discussions all over the world. And essentially, the idea is very attractive. In other words, you're trying to come up with general principles which should apply regardless of the technology that may be at hand. But in many cases, we explicitly don't do that. In many cases, we actually adopt specific technologies as part of a process. Identity is one of those. A signature, a CHOP, a biometric identity, a legal entity identifier. These are all specific technologies that we've adopted for a specific reason. But model law and electronic commerce tries to take a technological neutral approach with default rules and mandatory frameworks. Structure, general provisions, sphere of application, definitions, interpretation, and variation by agreement. And the key point is this idea of legal requirements to data messages. Article 5, legal recognition of data messages. Information shall not be denied legal effect, validity, or enforceability solely on the grounds that it is in the form of a data message. Writing, where the law requires information to be in writing, that requirement is met by a data message if the information contained therein is accessible so as to be usable for subsequent reference. Signature, a method is used to identify that person and to indicate that person's approval of the information contained in the data message, and that message is reliable as was appropriate for the purpose for which the data message was generated or communicated in light of all of the circumstances, including any relevant agreement. Try this again. Nope, still not working. Communication, formation, and validity of contracts, recognition by parties of data message, attribution of data messages, and acknowledgement of receipt. And so essentially the idea here is to be able to say that once it's implemented, that electronic contracts are perfectly acceptable, and our various formalities around making those contracts, for instance, in sales context, can be done in an electronic manner so long as they meet the necessities of that form of contract signature, etc. And the genericness, this idea of data message, has been something that has been usable in a wide range of context to support electronic commerce, and goes very nicely, if you will, with the carriage of goods by sea. I'm going to try one more time on this PowerPoint. Model law on electronic signatures. You can see this, a model law dating from 2001, far fewer states and jurisdictions which have actually implemented it. There is, of course, a question whether or not the model law on electronic commerce actually addresses most of the issues, and that has probably been a judgment of many states, is that in fact the model law on electronic commerce does do that sufficiently effectively. Data in electronic form affixed to or logically associated with a data message which may be used to identify the signatory in relation to the data message and to indicate the signatory's approval of the information in the data message. Think of our discussion around CHOPS and signatures and biometrics. Linked exclusively to the signatory. Signature was under the signatory's exclusive control at the time of signing. Any changes to the signature after the time of signing can also be detected, and where the signature is used to confirm the integrity of the related information, any changes to that information after the time of signing can also be detected. And you can kind of see, if one thinks about DocuSign, this is exactly what DocuSign does. But in most cases, one has had sufficient effectiveness as a result of the model law on e-commerce to get this effect. Convention on the use of electronic communications in international contracts. There was a view that perhaps because of the effectiveness or the attractiveness of the model law, that there might be worthwhile to move to a formal convention. But this is one of those examples where so far the take-up on the convention has been much lower than in the context of the model law. Model law on electronic transferable records. This one is relatively new, and you will see quite a lot of references to it in those two digital trade initiative documents that I've given you from the ICC. There's a view that this document, if implemented, could provide sufficient legal basis to support electronic versions of things like bills of lading. And so we're seeing an effort by UNCITRAL and a variety of other organizations, including the Asian Development Bank, ICC, and others, to push the implementation of the MLETR, the Model Law on Electronic Transferable Records. And so far, if one thinks about it, 2017, less than 10 years, so far adopted in 13 states. And if we look at it, some significant states. You can see the UK, UAE, Singapore, France, China as examples. China's adoption just last year. China just last year, Mauritius last year, Marshall Islands last year. We can see a number of jurisdictions which are thinking that this may be a mechanism to support greater digitalization of some of their commercial efforts. And this is an interesting one. We saw with the CISG that China was one of the early signatories from the very beginning of the convention. And of course, China's international commercial role at that time was largely as a poor developing country, a purchaser of things from elsewhere. But what is interesting to see is that over the past decade or so, China has in many cases accelerated its process of adoption and implementation of these sorts of international instruments to support commerce. In other words, China as a state, but also China as a commercial jurisdiction, is actually increasingly focusing on using these sorts of international frameworks as a way to support its own commercial transactions. If you think about it, often China is criticized for problems, weaknesses, issues with its legal system. So, to the extent that China can basically say, we have implemented an international framework which has been developed at a global level and which other countries have adopted, and we can put in place, remember last week, our international mediation organization, we can put in place arrangements for arbitration and dispute resolution which do not rely on the domestic courts of either China or its counterparties. This is being seen as a mechanism to support its ever-growing role in the context of international commercial transactions. So I think that's an interesting example to watch and think about, is from the standpoint of Chinese commerce, how it's organized, which is often the focus of our news stories, but also from the standpoint of legal arrangements, how those legal arrangements are increasingly focusing on international mechanisms. And of course, in something like this, it's a mixed bag in the context of our traditional large developed economies, whether or not they're pursuing this approach. I would say that the ones that you tend to see here, UAE, UK, Singapore, Mauritius, these are jurisdictions that are heavily focused on digital services, and the thinking that something like this could be beneficial. So, usual structure, scope, definitions, interpretation, party autonomy, privity of contract, information requirements, additional information in electronic transferable records, and legal recognition of an electronic transferable record. This is that point that some of our paper-based systems have legal effectiveness, and the effort here is to try to get the legal effectiveness in the digital version. Easier said than done. Writing, signature, transferable documents, instruments. General reliability, indication of time and place in electronic transferable records, place of business, endorsement, amendment, replacement of a transferable document or instrument with an electronic transferable record. So think about 17 and 18 are about the idea about how could we take some of these paper-based documents like bills of lading and actually replace them with digital versions. But in Article 18, it actually goes the other way as well. Is there a way to get a paper-based version out of the system, which also may be important in some context? And this idea of cross-border recognition and non-discrimination. The short answer, as we've seen from the Digital Standards Initiative, is there's a lot of enthusiasm, but progress is really, really slow on all of these initiatives. And over the next couple of weeks, we're going to come to one of those areas where the progress has been slow, which is letters of credit. And then second semester, we'll come back to the bills of lading process. I've already talked about all of this. This is essentially an effort to build common approaches for recognition of identity management and trust services. Very new model law, very limited take-up so far, but a lot of that is because it's very new. And I've highlighted an example, a real-world example of one of these sorts of digital identity systems, the Glyph legal entity identifier. And this one so far is largely working on the basis of contractual frameworks. Now, I want to go is back. For a couple of things to pick up from last time. Last time I flagged this issue around ownership or contractual responsibility for running the Panama Canal, and how we had had a Panamanian court which had recently held that the contract for Hutchison, a Hong Kong ports company, to run the port was constitutionally invalid. And it's just, I think, an ongoing, interesting example from the standpoint of commercial disputes, and in some cases, in this case, their relationship particularly to geopolitics. The initial issue was largely because the US argued that Hutchison, as a Hong Kong company, was in fact controlled by the Chinese government, and therefore China was controlling the Panama Canal. That was resulted essentially in Hutchison determining to sell not only their Panama port, but actually all of their port business globally. One of the challenges was to find a consortium of purchasers which would then be acceptable both to the US government and the Chinese government. That process of trying to negotiate an acceptable consortium had been ongoing, because it's not that easy if one is thinking about a global consortium of major ports, how an ownership structure could satisfy both the US and the Chinese government. It's an interesting question, because of course these ports are important not only from the standpoint of the US and China, but really of everyone in the world from the standpoint of cross-border commerce. And so control is a geopolitical issue, but in some ways it's also a sort of public good from the standpoint not only of these two as large commercial powers, but also from the standpoint of everybody else that is trying to ship stuff through these various major international ports. And of course, the local lawsuit comes into this with essentially local politics arguing that Panama should be running its own port, and so you get the invalidation of the Hutchison contract. And now we do have objections, particularly from China, in the context of that ruling. So China to pause Panama deals after ports contract canceled. China is asking state firms to halt talks over new projects in Panama as part of a broader retaliation after the voiding of contracts. So what we're seeing here is this point that I made at the very beginning. The entry of geopolitics, particularly amongst major powers, into the commercial context in a way that we haven't necessarily seen for a while. This one is interesting because your initial trigger comes from a US choice. We're now seeing Chinese responses as well as domestic differences. This is not looking like necessarily something that is going to end very well from the standpoint of really anyone. But it does highlight the limits of commercial dispute resolution processes. And this one is one of those stories that is certainly going to be evolving as the semester goes on. Now, let's think about this from the standpoint of ships. Now, this is interesting because one reason we're concerned about this port issue is because so much of international commerce goes by sea. Yes, I've highlighted that an increasing percentage goes by air, but there's lots of stuff that is just impractical to go by air, and it goes by sea. This piece is quite interesting because it highlights some of our big picture trends and how they're impacting the shipping industry. So, global container liners are bracing for lower profits as the potential reopening of the Red Sea shipping route weighs on freight rates, exacerbating oversupply issues and aggravating trade pains. Denmark's Møller-Mærsk, Germany's Hapag-Lloyd, Japan's Nippon Yusen, Chinese liners Orient Overseas, and COSCO Shipping are all expected to report weaker earnings in 2026 after an already difficult 2025 marked by tariff turmoil. So this essentially shows expected profit levels for major shipping firms. Ironically, note what's covering their profits. A resumption of traffic through the Red Sea would exacerbate existing structural overcapacity issues. Now think about this for a second. Red Sea, we were just talking about Panama Canal. Red Sea is Suez Canal. It's been closed for a variety of reasons. Because it was closed, shippers were charging more money for shipping, which had positively impacted their profitability. Shipping costs had gone up. Now that the Red Sea via Suez is reopening, freight costs are going down, which negatively impacts shipping companies. So it may be good from the standpoint of international commerce, but from the standpoint of the shippers, lower costs for shipping is not necessarily a good thing. Supply continues to expand at a record pace with a projected 36% surge in new vessel capacity from 2023 to 2027. So what is this? We're actually seeing an explosion in construction of large ships and the desire of a variety of others beyond our primary manufacturers, which tend to be South Korea, Japan, and China. We're now seeing a range of other countries which are looking to expand their production of ships. So from the standpoint of ships as a commodity, we're actually in a dramatic expansion, but we're actually seeing on the flip side, demand for container shipping is expected to contract 1.1%, assuming container lines make a complete return to the Red Sea. So in other words, we're seeing a dramatic increase in availability of ships. We're seeing easier shipping, dropping costs, but we're seeing pretty flat demand from the standpoint of actually shipping those things. What I want to pick up is actually a related story to this, which goes one step beyond. And this is Maersk, which is one of our biggest shipping companies, cuts jobs, sees drop in earnings as Red Sea reopens. AP Moller Maersk plans to cut jobs and focus on cost discipline this year as the container giant seeks to insulate its earnings against deteriorating freight prices. 2026 guidance is based on a gradual reopening of the Red Sea, which will free up global vessel capacity. Container line industry had benefited from the extra transport time needed to sail the long route south of Africa, which effectively lowered capacity worldwide by 7 to 8% at a time of fierce competition among ship owners for cargoes. Maersk is planning to cut 1,000 jobs, equivalent to 15% of roles of its corporate functions, but under 1% of total workforce. There will be a very sharp focus on productivity, including use of artificial intelligence applications. And this is where I wanted to pick up from the standpoint of technology. We're seeing quite a lot of businesses like shipping, like air traffic, seeing the ability to use AI to more efficiently structure business and operations. We're not necessarily seeing that from the standpoint of positiveness on the job aspect, but from the standpoint of efficiencies and costs. This is now something that we're seeing as a major focus. In other words, if you're a shipping company, as I mentioned, I think in the first class or the second class, it's already the case that you've structured your routes to go largely from major port to major port on a scheduled basis. You set up those routes on the basis of demand analysis, where you have had demand in the past and where you expect demand to be in the future. The design of your ships is related to the places they're going. Obviously, if you're going through the Panama Canal, there's a limit in size. As we saw in the first class, looking at the Arctic Circle, as Arctic ice-free sea periods increase, that provides a different alternative, but requires different forms of ships. And you're trying to essentially use big data on weather patterns, on fuel prices, on demand cycles to maximize the value that you get from each of your ships and to select in the best possible way the routes that those ships take. Containerization, essentially the creation of identical, effectively standardized shipping containers, which are used in a common way throughout shipping fleets and frequently also in intermodal transport, means that trade has been commoditized into standard box sizes. You can put anything in that box. And a term that we're going to look at a little bit more in depth later, freight forwarders. Freight forwarders are businesses that specialize in figuring out the best way to get stuff from place to place. And in many cases, what they do is they will take some clothing, some electronic goods, some tires, a few vehicles, and they will stick that all into a single container. Basically, the idea is to take a variety of different size shipments and force those into containers. AI is useful from the standpoint of big data analytics around predictivity, but it's also very useful from the standpoint of maximizing packing across all of these different containers. And as a result, from the standpoint of commercial transport, even though the ships themselves aren't necessarily changing that much, though we'll look at some of the fuel issues later, the way that those ships are being used as a result of new technologies does have big implications from the standpoint both of trade costs, but also how, from the standpoint of someone involved in commerce, you are actually able to ship things on a global basis with speed and, sorry for the shippers, but also at decreasing costs. Let's do one more. Actually, I'm going to do two. One, because it's fun. BYD sues Trump administration for a tariff refund. So BYD, car manufacturer, suing the Trump administration for a refund on the tariffs that it's had to pay as a result of changes. We, of course, have a US Supreme Court case which is pending on validity of tariffs. BYD is obviously hoping that it goes in one direction, in which case they may be in a position to gain from that. But this shows commercial litigation, and BYD, who we're going to look at some more. And last one for the day. Investment gold outshines jewelry in China amidst price surge. Obviously, we've had tons of price volatility recently. We've talked about gold as a commodity. In other words, you buy gold because you need it for a variety of commercial processes, from making chips to making jewelry. But you also buy it as a speculative investment. And in many cases, you actually buy it as a form of money, a sort of store of value that history suggests that if the world collapses and everything, all of our technologies stop working, people will probably still take gold. And so there is a constant demand from it for this. This is interesting because what it's suggesting at the moment is that gold prices are driving not purchases of gold jewelry, and one will see particularly in much of the world outside of Europe and North America, gold is often purchased as a savings tool in the form of jewelry. But values are such at the moment that people are just buying gold. They're not interested in the jewelry aspect. They are getting no value added from the jewelry side. And also from the standpoint of commerce, the investment demand is dramatically outpacing the commercial demand. But of course, what that's doing is it is driving up commercial prices of everything that needs gold as an input, which basically says for some things like gold, it's very difficult to separate that financial aspect from the monetary aspect from the commercial manufacturing aspect. All right, questions or comments on anything? So today what we did is we began looking at a specific area. We looked particularly at international sales. We looked at the Convention on International Contracts for the Sale of Goods as a formal hard law instrument, but one which has been highly successful. We then looked at a variety of mechanisms around technology and digitalization and how those are trying to be addressed in various forms. And finally, we looked at some of the ways that we're actually seeing commerce changing around the world. All right, next week, on to money and payment. One last thing. I'll send an email There'll be a notice that comes around tomorrow morning. Remember, we have our first tutorial groups this week. So there are 3 different groups. You should be assigned to one of those. There is some flexibility if you want to go to one of the other ones. I'm not terribly bothered by that, but generally you are assigned on the basis of your timetable. So I will look for you all in those tutorial groups later this week. Yeah. The code again. Okay. Hey, yeah.
I have a lot of questions.
Yeah, no problem. It's good.
You explained to us earlier about the bits of lading and how they become digitalized and sometimes how like a digital bit of lading can also serve a legal function as a paper one.
Exactly.
I'm just wondering, since the bill of lading actually the proof of ownership is the actual physical possession.
Exactly.
Yeah, so how is that applied in a digital one?
Yeah, that's the challenge. Is the problem is with digital that it's not unique.
Yes.
And so it's been almost impossible to get a sort of digital bill of lading that works. The only systems that we've seen so far have basically been closed systems. But if it's closed, the challenge, it means that it's just everybody in the room. So you have to be approved to come in. And therefore we can track who has it. And it can be the representation. But the problem is that the benefit of a bill of lading is that it can go to anybody. And so, trade, I'm sure you can get a lot of people together that are, shipping companies, banks, but not everybody. Because there's so many different little traders and shippers, and it's almost impossible.
So it's a kind of a challenge of
Yes, exactly. Because your risk is always that once it's been digitalized, you can make any number of them, and it doesn't work. So everybody sticks with the paper because it works. Yeah, no problem.
Thanks so much.
Yeah.
Couple of questions will take a minute. In order to get this attendance in the past time is when we need to have the meetings. So how do I ensure that I get
Just once you're in, send me an
an email? We were just studying this as a means
So it'll be more, sort of like what we did today.
a few questions in specific relation to the tax and SaaS.
Okay, tax we won't be doing.
No taxes, SaaS. Software.
No, we won't be, because we're basically just doing goods and not services.
Is there other modules like this?
Yeah, there should be probably the e-commerce one.
But like, as like, is the discipline for area of expertise or something? There's a few dollars doubts relating to this.
Send them over, and it's something that maybe, depending on what it is, it may relate, and I
Then, for reference of technology, commission, any reference books in mind?
can.
And third, attendance. I'm not able to get send the email for that as well. Perfect. You mentioned reference to some mediation which happened last week. Can you tell me more about that?
It's an organization I mentioned last week, which is the International Mediation Organization.
Yeah,
Yeah, that's it.
okay, so something.
Yeah.
That's it. Cool.
Yeah.
With respect to the phenomenon, shouldn't the companies be focusing on the volumes instead because routes are not open?
Yeah, so that's, I think the key challenge is really the capacity that they built. They're building so many ships, and the fact that, and shippers will see this, but shipping companies, they go through cycles where sometimes they build too many ships and then the prices collapse, and then they stop building ships, and then over a decade the prices go back up. So then they start building
This
ships.
collapse is majority to do with the construction of the ships and not with the shipment, like the volumes of the inventory. Got it.
But if shipping volumes were growing very rapidly,
Yeah.
that would be good. Shipping volumes are pretty stagnant, but ship capacity is increasing. So demand is stagnant, but supply of ships is going up. And this happens with shipping periodically.
But this is again very curious to me that why is it happening? Because they again have a lot of
It's like oil
space
prices.
demographic for
It's like oil prices.
crossing through
Sometimes the
volumes.
when the prices go up,
Yeah.
they expand capacity, which brings down prices. And then when prices get too low, they cut off capacity.
Yes.
And then eventually prices
Prices goes up.
it's the same.
Okay. Thank you,
Yeah.
Professor. It's brilliant. Good man.
Quick question.
Yeah, yeah.
What time are your other tutorials?
I'll send around the email with the details.
Oh, okay, thank you.
Yeah, you're welcome.
Hi,
Yeah.
I would like to ask, the other day you said that I should email you about this.
Yeah,
This
it's
was
still not
like-
working.
Yeah, I sent email already, but it's not working, so I'm
Okay.
not sure, like.
So I haven't gone through the email to
Oh,
everybody,
okay, so
I'll do
it's
that this
okay,
week.
right?
Yeah, yeah.
Thank you.
Hey,
I was wondering if I could change the tutorial name.
just, I can't, so if you want to formally change it, I can't do that, but I don't really care which one you turn it to.
Okay, can we do it formally?
That you'd have to go through the.
Administration.
Exactly,
Okay, and I'll tell them and it's okay.
probably. And even if they say it's not, you can still go to one of the other ones, because I don't really care.
Oh, okay. Okay, thank you.
Yeah.
So I came a little late to this session, so I wanted to ask, what are the tutorials about?
Well, probably, I usually take a few news stories and we go through them in detail.
Okay, that's pretty much it. Okay,
Yeah.
all right, thank
Yeah.
you.
Hey.
Yeah, excuse me, question.
Yeah.
You are talking about the group on Friday.
Yeah,
Yes, class.
there's actually one on Thursday and two on Friday, but each of you will have been assigned
Thursday
one.
and the Friday.
Yeah,
I can't choose, right?
you're welcome to turn out if you want to, yeah.
Yeah, because Friday I have corporate class.
Okay.
It's same time. So can I take it on Thursday, right?
Yeah, I'm perfectly happy for you guys to turn up to whichever one you want.
Yeah, thank you so much.
yeah.
So on Thursday, what time?
I'll send around the note with the details for everybody, and now we can just.
Okay, thank you so much.
Yeah, you're welcome. See you guys later in the week. Yeah,
Do you mind if I ask a question?
yeah, please.
What will be in a tutorial on Friday?
We'll largely go in detail through some of the things we've already looked at, and probably also some news stories. So.